The court calls Gyger versus Clement. We're glad to have Ms. Daly and Mr. Daly here today, and Mr. Wharf. We welcome you to these historic virtual oral arguments. It's the first time and the third day that the court has hosted virtual oral arguments in its 200-year history. So we welcome you and those who are here to view them. Ms. Daly, I understand that you will argue for 20 minutes and you will split your time with Mr. Daly, and he will argue for 10. Is that correct?
Approximately.
All right. And is his argument now rebuttal?
No, he will. I will leave him time for a rebuttal.
So I'm sorry. Will he? So is he arguing on rebuttal, or are you both? Or
I am arguing initially, and I actually planned for my argument to take only 10 to 15 minutes.
Okay.
And then I'll leave the rest of the time for him to rebuttal.
Okay, that's fine. Thank you.
Should I go ahead and start?
Yes, ma'am.
Okay, thank you. May it please the court. My name is Anna Daly. I represent the plaintiff in this case. I'm an attorney from Mecklenburg County. This case arises out of a case in the District Court of Guilford County. Plaintiff, who is a resident of Switzerland, obtained a judgment for paternity and child support in Switzerland against the defendant. She registered it for enforcement in North Carolina pursuant to the Uniform Interstate Family Support Act, which is codified in North Carolina as General Statute 52C. The district court declined to enforce the Swiss judgment on the grounds that the Swiss record did not sufficiently show service of process on defendant. Plaintiff then filed a Rule 60B motion and attempted to introduce an affidavit which, among other things, had exhibits showing service of process on the defendant, but the court declined to admit her affidavit as it was not notarized. This court has taken up discretionary review of the case and is asking the question of whether North Carolina General Statute 52C 315B, which allows for affidavits to be admitted into evidence if given under penalty of perjury, whether this requires that the affidavits also be notarized. The word notarized is not used in the statute. It simply says that it must be given under penalty of perjury. So the question before the court is a simple question of law. Does the word affidavit require an oath? The statute doesn't answer the question of whether an affidavit must be notarized under oath. Neither the word notarization nor the word oath is mentioned. The word affidavit is mentioned, but not defined. So the statutory text does not answer the question of what the word affidavit means in the context of this particular statute.
So Ms. Daly, for clarification, am I correct your argument is based solely on the requirements of an affidavit under Chapter 52C?
Yes.
Your argument does not extend to any other provision of the general statutes that use the word affidavit, correct?
Well, that's correct, Your Honor, because the question that was certified specifically references 52C. So our argument is based only on 52C. It would not necessarily affect any other statutes that required affidavits.
And your point is that the legislature has expressly relaxed the evidentiary rules that otherwise apply in Chapter 52C?
Yes, exactly.
Thank you.
So look into the context of the statute. It appears that clearly that a declaration of perjury without an oath is sufficient by itself for several reasons. First, we look at the statutory history, and as Your Honor mentioned, the statute has been amended and the requirement for an oath has been removed. At the same time, section 311 of the same statute, which deals with special cases of child abuse and child custody, was amended, and the word oath was not removed. So it appears to me that some thought went into whether oaths should be included in the statute. They left it in one, they took it out of the other. Defendant's interpretation of the statute would tend to lead to a slightly bizarre result. If the statute were to require a declaration under penalty, adding a requirement of an oath before a notary would essentially require both an oath and a perjury declaration. And in many ways, they're the same. An oath under penalty of perjury is a legal oath. It's a profane oath. It's an oath before a notary, you swear or affirm, so it's more of a sacred oath. But they essentially achieve exactly the same result. So it's not, we don't believe that it would make sense to have both in the same statute.
I'm not sure I'm understanding Mr. Wharf to argue that. He, of course, has got the right to tell me that I'm misunderstanding his argument, and I hope he will when he gets his chance. But it seems to me his argument is, in essence, that an affidavit is something very specific in law, and that the fact that we use the word, or the General Assembly used the word affidavit in the relevant statutory provision, by definition, requires an oath, and presumably, I guess he would argue that once you have an oath, it's made under penalty of perjury, and therefore that portion of the statute is complied with as well. Assuming that that's his argument, what's your response to it?
Well, I don't believe that that is correct. Statutes change, languages change. If you look in Black's Law Dictionary, the 5th edition says that an affidavit must be under oath. The 6th edition and all editions forward, which cover the time span of this case, all say that an oath is not required. So the definition of the word can change, and we really need to look at the context in which it's being used to figure out if one's required. I don't personally know of any source that says definitively an affidavit must require an oath. I don't think it's in the general statutes anywhere. I haven't seen it anywhere else. And
So I have a question about this statute, because 52C-3-315B says an affidavit, but then it also says a document substantially complying with federally mandated forms, or a document incorporated in any of these. So what is a document substantially complying with federally mandated forms?
well, I'll give you a brief answer and then leave the remainder of that question to my father, who's a little more knowledgeable about that subject. But essentially, there are federal forms for these international transactions. And in this case, it just needs to comply with what the federal guidelines say. And I, if you don't mind, will defer,
Sure.
Defer the rest of that to him.
Do you have a response to Mr. Wharf's argument that the penalty of perjury language was intended for the purpose of facilitating the use of federal forms and for no other purpose?
Well, I believe that the I'm not sure that that's correct. The use of penalty under perjury is in plenty of other statutes that don't require federal reforms. It's just in this particular statute.
Are you familiar at all with the federal Rule 28 U.S. Code 1746, which has been interpreted and applied by the federal courts that unsworn declarations under penalty of perjury, which allow what we would call affidavits in state court to be introduced in circumstances in federal situations, simply with under penalty of perjury without any oath requirement?
I am not, but I can tell you that under different, well, for example, we have a COVID crisis in this country right now, and the Chief Justice issued an order, I believe it was Directive 5, which said that any pleading motion or affidavit no longer had to be notarized. It was sufficient that it be signed under order of perjury, which is what happened in this affidavit. It recognizes, the court recognizes that there are some circumstances where if you're having a pandemic, if you live in Mongolia, if you are in a refugee camp, you just don't have access to a notary. So the modern approach to affidavits is to make them easier, is to make it less of a burden on people, particularly people with fewer resources, to get to a notary and get their affidavit signed. And let's see, I can't see the clock. Can anybody tell me what time is left on the clock?
You have 18 minutes, 40 seconds.
18 minutes, 40 seconds. Thank you very much. At this point, I think I will cede the remainder of my time to my co-counsel, George Daly, for rebuttal. Thank you very much.
Oh, for rebuttal, or, okay, so you don't want him to argue now?
Can you ask him?
Maybe you should ask him.
Dad, do you want to argue now or do you want to wait for rebuttal?
I think I'll, if I may.
You may.
All right. Thank you very much. May it please the court, from the Mecklenburg County Bar. I would like to respond to add a couple of things. This statute derives from the Uniform Interstate Act of 2008. And as quoted in our brief, the statutory comment to that act makes it very clear, to my mind, that the purpose of the amendment, the 2015 amendment, was to, if I can find my reply brief here, I'll read it. The 2008 amendment says, subsection UIFSA 2008 amends section 316B to eliminate the requirement that an affidavit document must be given under oath. That's a very definitive statement. It clearly says that you don't any longer need an oath. The statute itself does not precisely say that, although it says that in substance. Secondly, I would like to speak to Justice Earls' argument about the other clause of the statute. As I understand it, there would be cases in which both the first and second clause of the statute cover the same thing under our interpretation, which to me creates no problem. There may well be other cases where the first clause covers things and the second clause wouldn't, but it doesn't seem to me to make much difference that in this particular case, I think they both cover the same thing. In fact, we were very puzzled in the Court of Appeals because we made the argument that we had clearly satisfied the second clause, and the appeals did not consider that argument. It not only did not consider it, but it omitted the second clause of the statute when it quoted it, as if the argument had never been made. The argument here, though, doesn't concern clause 2. It concerns clause 1 because the court specifically granted discretionary review on that issue. There is another aspect of what the statute does other than dispensing, and that is, in the plaintiff's view, it dispenses with the need to have a third party authenticate that the signer of the affidavit showed up and signed it, the self-authentication function. And we think that this is quite clearly what the statute provides. If you look at section 315F, which talks about positions in these types of cases under these special rules, and they are specifically said to be special rules. And it seems clear to me, in answer to the initial question that was posed, that we're just talking about section. We're not talking about rear-end collisions. We're not talking about criminal cases. We're not talking about generally adopting the federal rule. We're just talking about how to interpret this one special statute which applies to documents coming in from foreign countries. That statute says that a deposition or a hearing under penalty of perjury by telephone. And it says nothing about authenticating that the person on the other end of the telephone is actually who that person purports to be. That, of course, is a problem that the federal courts have dealt with for 46 years now. You get an affidavit in, it's signed by George Daly. There's no certification at all that George Daly actually signed it. That is less with an oath, but of course the main point we're trying to do here is to get people to tell the truth. And the best two ways to get people to tell the truth is to do some discovery on them and take their depositions. And the formality of having them appear in front of a notary public, particularly when they're in Afghanistan or Somalia, and it's hard to get those certifications, and in some cases it's we think possible and expensive. We think that it's quite okay to allow a certification simply under penalty of perjury without having any independent way of authenticating that the person is there. And in this particular record, there is a truly vast amount of authentication. It was the plaintiff who in fact signed. Her signature was in the record before the district court that was sent over from Switzerland. It was in that record 3 times. So it could easily have been compared with her signature on the affidavit. The case number in the documents which she wanted to present attached to her affidavit was the same as the case number of the documents that had been sent from Switzerland. That case number appeared 27 times. It had some letters in there to the defendant, which the defendant admitted receiving, apparently service of process, 2 certified Swiss postal receipts, We deposed him and he said,
I'm sorry, counsel. Are you saying the similarity of signatures as to prior documents should be sufficient to determine whether or not there is a bona fide binding signature, or are you just saying that would be corroborative evidence and you're just offering that as just another way to feel as though this is an appropriate fashion to not have an oath?
I'm saying that in this statute to require only penalty of perjury, one of the issues that could well occur is what do we do about authenticating that we have the actual person here? And I'm saying that in section 315, it allows that problem to go unnoticed because it says you can testify by telephone. I'm also saying in this particular record, there are lots of facts, which I went through perhaps with too much detail, which show that this was an authentic record. And I think that'll be these things. So I think that you can easily justify getting rid of the notary's function of authentic person appeared before the notary. That's been the case in federal court for 46 years.
I was wondering if you were expanding your on the penalty of perjury argument to say that you could even go so far as to compare signatures, and if signatures appear to be identical, that would be sufficient as well in lieu of an oath.
No, I'm just saying that in considering the general question of whether to not require the notary's function of identifying the party, that in this particular record, that's a method of authentication that could have been used alone. No, we're not resting on that alone. This statute has two purposes. One is to simplify matters because organizations abroad are expensive and difficult to obtain and sometimes impossible to obtain. And of course, any statute dealing with witnesses, one of the purposes is to make sure that the witness tells the truth. And I suppose I'm saying that the notarization is pretty far down the list of what we've all learned to expect to guarantee that a person tells the truth. In my experience, what makes a witness tell the truth is the fear of cross-examination and having been stated on discovery. And finally, I would like to emphasize again the point that we are only contending for a rule limited to this particular statute. We are not contending to subtly interpret the North Carolina statutes to incorporate the federal rule wholesale. This is a case about 315B. Thank you very much.
Thank you. Mr. Wolf?
Madam Chief Justice, may it please the court. My name is Martin Worf with the law firm of Nelson Mullins, and I represent appellee Mr. Quentin Clement. The issue before this court is whether section 315 of UIFSA redefines affidavit to be an unsworn declaration under the penalty of perjury. It does not. And the Court of Appeals did not err in affirming the trial court for three principal reasons. First, the word affidavit has a plain, unambiguous meaning. Second, section 315 lacks the clear intent of the legislature to alter this plain language definition. And third, the relaxed evidentiary rules of section 315 are not applicable in a Rule 60 hearing that follows the final decision to vacate a registration order. As to the first of these, Your Honor, an affidavit is referred to nearly 400 times in the general statutes, including the rules of civil procedure. No indication in these references suggests that it means anything other than a statement sworn in the presence of a notary or other official. Being sworn before another official is how the affidavit is defined.
Let me ask you this. Again, I apologize because I don't know that your practice areas, but are you familiar with the federal practice and with the federal statute and its interpretation and application that all that's needed is a statement in the form saying under penalty of perjury?
Yes, Justice Newby, at least enough to work with this argument anyway. We do use federal declarations when we are practicing in federal court, but we typically advise anyone practicing in state court to not use a declaration under penalty of perjury because it is not the same as an affidavit. Federal courts refer to it as a declaration, and you can see on pages 8 and 10 of our brief that even federal courts who have the ability under section 1746 of the U.S. Code to use a declaration under penalty of perjury still refer to affidavit to mean a statement sworn before an official. So where in federal court those may be equivalent, they are not the same. And in state court, we do not have the ability to use a declaration. And as you note, nothing in section 315 uses the word declaration that would help to incorporate section 1746 into that.
So
I
would
guess-
you at least concede, the second phrase that talks about federal forms, that as long as that complies with federal statute 1746, that they would be admissible?
Yes, Your Honor, the federal forms, yes. And we've, to your point, and maybe this answers Justice Earle's question, several federal forms are in our appendix page, I think starting at 22. And you can see the general petition form that has been adopted by the Uniform Code and also a general testimony form. Both of those have the applicant sign under penalty of perjury, and those are certainly admissible. But as you can see,
Can you tell me a reason why there would be a distinction between the phrase affidavit and then the second phrase, the federal forms? In other words, what would be a policy reason that, well, if you use a authorized federal form, then all you have to do is say under penalty of perjury. But if you call it an affidavit, then you've got to somehow find a notary.
Well, as you can see from the commentary, official commentary to the section 315, the commentary notes that before it was amended in 2001, the 2001 amendment actually changed the word oath to penalty of perjury. Before it was amended, the statute had the word oath there, which would apply to a federal form. So you would need to take that federal form to a notary to have it executed before you could use that in your interstate case. Here, with the change, now you can use the federal form without going anywhere else. You can execute the federal form yourself. But that federal form is not an unlimited repository of information. So the commentary uses the comparison to the tax form 1040. And certainly, if you're filling out your 1040, you can sign under penalty of perjury. But if there's a question about whether you sent it in timely or not, you're going to have to use another document for that, similar to what we have here. What was included when the court file was sent to Guilford County?
Let's look at the grammatical structure of 315B a little bit, if you would. As you said in response to Justice Neby's question, you've got references first to an affidavit, secondly to a document substantially complying with federally mandated forms, or a document incorporated by reference in any of them. And then you've got this language about we've got a clause that talks about hearsay issues, and then it finishes up by saying if given under penalty of perjury. Is your argument that the language penalty of perjury only applies to the provision that talks about federal forms? And if so, how do you get there grammatically?
Thank you, Justice Irvin. I do agree with your breakdown of the statute that you got affidavit, document substantially similar, or a document incorporated with any of those, and you've got your 3 tag-alongs.
And would you agree that the penalty of perjury language applies to or modifies all 3 of them?
I think that is the way to read it. It is not exactly clear, but I do believe that is an appropriate way to read it.
I was not a great grammarian when I was in middle school, or actually, I'm so old it was junior high school, but that's the way it looks to me. If that's the case, then why doesn't under penalty of perjury modify affidavit?
Well, I think when you look at it, Your Honor, as I've noted before, when you take affidavit to have a plain meaning, which is this court in Fidelity said is an unambiguous word that has definite and well-known sense in the law. Outside of this single reference in the general statutes, an affidavit contains 2 parts to it. One, some form of a swearing or an oath or a statement under penalty of perjury. But the critical piece of the affidavit, which makes it different from a declaration, is that it is done before a notary or other official. So when you read these 2 together, while you may be able to use a document under penalty of perjury, like substantially similar to a federal form, is there enough clarity here to say that the General Assembly intended to do away with the presence of a notary or other official when taking an oath or affirming with an affidavit? I think the likelihood is because they are allowing these documents, federal forms and potentially affidavits, to come in the lieu of live testimony in a final hearing. It doesn't seem substantially hard to me to say where you're going to use a federal form and stick to basically what we believe should be in front of this hearing. We're going to make sure that that is done as easily and efficiently as possible by allowing that to be executed under a penalty of perjury. But when you look at an affidavit, which by its content could be unlimited, you need to give that oath or give that statement under penalty of perjury, applying that subpart of the statute. But that does not do away with the fact that that penalty of perjury needs to be indicated in front of a notary.
My understanding of the plain language, lack of ambiguity rule of statutory construction is that you use if you've got an undefined term, you assume that you use the plain language determination unless context shows otherwise. Is your understanding of that rule similar to the way I badly stated it?
No, you're hitting it on the head, I think. But the idea here is, as Ms. Daly pointed out, affidavit is not defined in this section as a word in and of itself. So we would apply its plain meaning, and its plain meaning would be similar to the references that we see in numerous other.
Wouldn't you apply the plain? I mean, don't you have to, in order to apply that rule, don't you also have to look at the context in which the word appears in the particular statutory provision?
Yes, Your Honor. And I disagree with Ms. Daly's interpretation of section 311, which contains the only other reference to affidavit in the same article of reduced evidentiary burdens. When you look at section 311, you can see that phrasing and using the word article and an A, the phrasing is an affidavit or a pleading under oath. And I think the purpose there is to note that those are equivalent. An affidavit implying obviously that you are giving an oath before a notary, or a pleading under oath. Either one of those is okay to protect the non-disclosure of information in those exceptional circumstances. But I'd be hard pressed to say that within the same article, 2 sections away, it talks about the evidentiary burden, that affidavit would have a different meaning than it does there, which is equivalent to a pleading under oath. In particular, when you look at the official commentary to section 315, which, as you note in subsection B, the official commentary focuses solely on the forms. It reads, section B recognizes a pervasive effect of the federal forms promulgated by the Office of Child Support Enforcement, which replaced the necessity of swearing to a document using the word document, not affidavit. Document is in section 315 of the text. Affidavit is in section 315 of the text. The official commentary only uses the word document under oath, with the simpler document being under penalty of perjury, as has long been required by the federal income tax forms. Even later within that same commentary, you can see when they look at subsection D, the court notes that we're going to allow, or the General Assembly notes, we're going to allow business records that would normally need, and the quote is, an affidavit of business records to be admissible. We're going to allow those to come in just being basically no one in the historic use of those documents in UISA. The framers have said, well, we don't really ever see anybody arguing about that, so we're going to let those come in as they are without an affidavit of business records, but they use the phrase affidavit within the commentary itself. And I think that supports the idea that there is still using the plain language of the term as we see it throughout the other references in the general statutes. And when you also look at when you read those two together, when you read section 311 in with 315, and you look at the words affidavits together there, I think it's clear to me that the court is not trying, the General Assembly is not trying to change affidavit, even in section 315, to necessarily mean without a notary. But what they're trying to do is allow more use of these federal forms that before 2001 actually needed to be sworn under oath.
But don't we, if I can just ask you a question about the official commentary to the Uniform Act, don't we have some indication of what the North Carolina General Assembly meant in enacting section 315 from the official comment to section 316, which was enacted verbatim, and as the plaintiff appellant indicates in the reply brief on page 3, that official commentary explicitly says that the statute amends section 316B to eliminate the requirement that an affidavit or other document must be given under oath in order to be admissible in evidence. Rather, it's sufficient if the information is provided under penalty of perjury. Isn't that a pretty direct statement of what the intent is behind this particular section?
Your Honor, I do think that's a direct statement, but I do not believe it goes to the intent of the statute, because in fact, that's not the official commentary to the amendment. And I know that counsel for plaintiff has cited that as the official commentary, but I don't believe it is. That is featured in their brief, in their appendix at page 72. And if you look at that, Your Honor, Justice Earls, you can see that on page 72 of their brief, the first page of that reference point notes that it does discuss the 2008 revisions to the Uniform Interstate Family Support Act, but they note that this is just a technical assistance tool for state and local support agencies. And then they refer to the fact that at the bottom, all references to UISA are to the official law commission version of the 2008 commentary, and including that commentary. So I went and actually, because of the reply brief, I pulled that document as a source. And that document, when you look at the 2008 amendment, the only amendment to the section that we're looking at is to change the words in another state to outside this state. The amendment from oath to perjury was in 2001. But when you look at the official commentary to that amendment by the Commission of Uniform Law Examiners, they do not use the word affidavit at all. Again, it's very similar to what you see in North Carolina with subsection B recognizing the pervasive effect of federal forms of swearing to a document under oath, similar to penalty of perjury like we have in the federal tax form. It's basically the same thing that we have in the official commentary for North Carolina. So I think that is a possible interpretation of this, but I do not think that interpretation is correct when looking at the official commentary to both North Carolina and by the commissioners themselves.
Mr. Worf, if it had been shown that the plaintiff had given false information in this document, could she have been potentially prosecuted for perjury?
Your Honor, I would assume so. She is saying that she would be subject to the laws of the United States for penalty of perjury, but I don't exactly know how that would work when she is a citizen of Switzerland. So I would have to unfortunately say I think she is saying she would be considered under a penalty of perjury if proven to have falsified information. But I don't know exactly how that prosecution would work from someone in Switzerland.
But if that is in fact the case, isn't the document serving the purpose of an affidavit?
Well, Your Honor, I don't think so, because it may be equivalent to potentially an affidavit, but it is not an affidavit. And it is not a federally recognized, substantially similar to a federal form, because what Ms. Gyger purported to do in her affidavit was actually serve as what we might refer to an affidavit of service of process under Rule 4J2. She was basically trying to say, here is a copy of the court file, and here's some records in it that show there was some documents received by Mr. Clement. But there is no indication whatsoever of what was sent to Mr. Clement. And that is typical of what you would have in proving an affidavit of service of process. It's not just that I mailed it, but what was mailed, what was in the envelope when the receipt was given.
Let me go back to a question Justice Ervin asked earlier. I'm not sure I understood your answer or remember your answer. Did you concede that the phrase if given under penalty of perjury in the statute modifies all three: affidavit 1, document substantially complying with federally mandated forms 2, or document incorporated by reference 3?
I think, to me, going to the same schools of Justice Ervin and grammatical, that's the way I would read it, yes.
So if that's true, wouldn't it be redundant? Wouldn't it be surplusage on the part of the General Assembly to use the phrase under penalty of perjury, given that it's understood that affidavits are always under penalty of perjury?
Well, I don't know that it would be, because in North Carolina, for instance, we don't necessarily have a defined language for an oath. So you might see in some affidavits that it is sworn. You might see that I swear to tell the whole truth and nothing but the truth. But I think this particular phrasing is really the equivalent of saying this is the type of oath that we're going to use. You're going to swear under penalty of perjury.
But the word oath doesn't appear.
No, the word oath doesn't appear, but when you look at the 2001, prior to it existing in 2001, which is in our appendix before, you could potentially say the same surplusage existed then, when you had a verified pleading of an affidavit or a document substantially similar to federal forms, et cetera, under oath. The word oath was changed to penalty of perjury, but naturally an affidavit was also under oath. But that oath was not clear, and there could be many different oaths in different states or different jurisdictions. So
isn't one reasonable interpretation of this particular statute as a whole to relax evidentiary rules that would otherwise apply?
Yes, that is the main purpose of the statute, but I don't think that purpose would apply to changing the definition of affidavit, because it's not as if it's very clear in saying an affidavit no longer needs to be executed before a notary as long as the oath or the swearing is under penalty of perjury. That clarity is lacking. So I think the purpose of the statute was to definitely lower the evidentiary bar to allow these forms to come in, but not to change the plain meaning of the word affidavit.
And finally, let me go back to the question Justice Earls asked you a few minutes ago. I didn't completely understand your answer. As I think you said that the language she quoted was not the official commentary. So what do you claim it was, and what effect does that language have in our interpretation?
Well, it is language that is from the prepared by, I think, the body that the Office of Child Support Enforcement but it is not language about the official commentary to why the act was changed, why the uniform laws were changed. So I think similar to Mr. Daly, it is an interpretation of that, but I do not believe it is an appropriate interpretation when considering that North Carolina specifically has not ever defined the word affidavit to mean anything other than a statement executed before a notary. And I think to have some clarity that the General Assembly, in adopting a model code, intended to change that plain meaning, similar to the Fidelity case, you would need some sort of clear and specific reference to that. And I don't believe that this statute provides that when there is a plausible read for affidavit to still mean in front of a notary or an official. There are clerks who can issue affidavits as well.
We've been talking a lot about the substantive statute here, but this aspect of affidavits also arises in the context of the usage of Rule 60B. What would you have to say about the intersection of this statute, which is the substantive one, with Rule 60B as pertains to the use of affidavits, as the other side urges?
Thank you, Justice Morgan. I think when you look at these reduced evidentiary rules, which are codified in Article 3 of the UIFSA, when you look at Section 303 of that article, which contains both of these evidence, the statute notes, except as otherwise provided in this chapter, a responding tribunal, which here will be Guilford County, this state, shall apply the procedural and substantive law generally applicable to similar proceedings originating in the state, and may exercise all powers and provide all remedies available in those proceedings. But to me, Your Honor, I think what the court is saying, what the General Assembly is saying is that while we have these relaxed evidentiary rules for determining whether to register a particular order or concerning the hearing itself, that hearing was done. There was no appeal from that hearing. Judge McSwain entered their final order, and plaintiffs filed a Rule 60B motion to have this issue brought up. And when you look at Rule 60B, Your Honor, affidavits are
Well, before we go there, Mr. Wharf, help me with something here in GS 52C-3-3031. It says that except as otherwise provided in this chapter, responding tribunal shall apply all the procedural and substantive law generally available in similar proceedings, and may exercise all powers and provide all remedies available in those proceedings. Rule 60 is available in all civil proceedings. This is a civil proceeding, I think. Why isn't Rule 60B part of the proceeding?
Well, Your Honor, I don't think I would be advocating that necessarily Rule 60B would not apply. It is not clear that Rule 60B would apply to a hearing, but what my point is the hearing for the reduced evidentiary burden is done. When the plaintiff brings a Rule 60B motion.
All right, but then maybe that's the problem. Maybe that's what I'm not getting. Why once we get to it, assuming that this is a civil proceeding, I think we can hopefully agree on that. If I'm wrong about that, please elucidate why I'm in error. Assuming that that's correct, assuming that Rule 60B is an available remedy in a proceeding like this, why isn't whatever an affidavit is for purposes of 315B the definition of affidavit that would apply in Rule 60B when a Rule 60B motion is filed in a proceeding covered by 315B? I'm sure I've confused that up so much nobody can answer.
No, I do understand. I think, to me, what you're saying
that says a great deal for you, Mr. Wharf.
Well, why would we not just continue the relaxed evidentiary burden that's present in Section 315 to a Rule 60B hearing that's dealing with vacating a registration?
That's a much better way to put my question.
Well, and I think the commentary helps us answer that. the commentary to the rule, when you look at 315, notes that these subsections provide exceptions to otherwise guiding principle of UIFSA that local procedural and substantive law should apply. And then when you look at the commentary to 303, which notes in its text, except as otherwise provided, we're going to go with the normal rules of court. Section 303 says that these rules supplement the forum state statutes and procedures governing support orders to ensure the efficient processing of huge numbers of interstate support cases. It is vital that the decision makers apply familiar rules of law to the maximum degree possible. And I don't think there's anything in UIFSA that would suggest at all that the relaxed burden in section 315 would apply to a Rule 60B hearing in an effort to show that the trial court had a mistake of fact or some other issue to set aside that previous order, because in fact—
Could you use a federal form executed under penalty of perjury in a Rule 60B motion in one of these proceedings?
I think you could potentially include it with, like, if it were attached to your affidavit, but your affidavit to determine to—
And I'm sorry, that was a vague question. Assume that all you've got, that you don't have anything that you and I might traditionally recognize as an affidavit under the standard definitions that's set out in the cases the Court of Appeals relied on.
Right. I think then no, you could not use that form, because what you're doing there is asking a different judge or even the same judge to set aside a prior final verdict that totally fulfilled the purposes of UIFSA. There was either—
So the rules of evidence, your argument is then that the rules of evidence that would be applicable in this proceeding change at the Rule 60 stage?
Yes, and I think that's sort of consistent with what Mr. and Ms. Daly were saying when they said they're only looking at Section 315. They're not looking elsewhere to the rules of civil procedure or other things. And we see the rules of civil procedure being invoked to go after a final order in another case. I think there, to say that affidavit could be anything other than a sworn statement in front of a notary opens up a really big ambiguity to what other people are going to do in a Rule 60 setting. Rule 60 is fair and just equitable remedy, but you need to have a material impact. Even if you are able to get that in, you need to have a material impact on the case before you could reverse or change the verdict of the prior one. And for that purpose, I think here, I'll just close by noting 3 facts that are relevant here. First, when you look at the translated order originally from the Swiss court says that there was a summons issued, but there was no finding of service. There was no affidavit or proof of service in that file. That's at record 22. And when you look at the agreement between the Swiss and the United States of America signed by Ms. Gyger, it does not, when you look at, that's at record page 14, there's a place where you can check for a proof of service being added. There's no check mark on that form. And finally, when you look at the affidavit, if that's what she intended it to be, she fell short of that. But when you look even at the statement of Ms. Gyger on record page 49, she says she does not know what documents were served. So even if we were going to try to use this as an affidavit of service, it would not work. And for those reasons, Your Honor, I would ask that this court affirm the Court of Appeals or otherwise determine that discretionary review is improperly allowed. Thank you for your time.
Thank you, Mr. Wharf. Mr. Daly?
First is the real fight between the two sides goes to the question of whether an affidavit is now and forever a document under throughout the defendant's brief, he constantly recurs to that supposition. When the word affidavit is used, it means oath. But the general statutes, as far as we know, never define the word affidavit. They use it many, many times, but they never define it. An affidavit, I don't know whether to call it a writ, but it's certainly a common law artifact. It's a tool that we've used in court to bring forward testimony, and it is a matter which courts have the power to define. There's no rule graven in stone that they must require an oath. And I would cite particularly to the case, I don't remember the name, but it's that 1884 case, which the Court of Appeals quoted, which sets forth at great length the requirements of an affidavit. That's a common law court construing what an affidavit means. And that's what I'm asking this common law court to do in the circumstances of this particular very remedial statute, to construe what an affidavit means. It says affidavit, penalty of perjury. It doesn't say anything about oath. One more point, if you please, and that Rule 60B, it appears to me that that's right clearly outside the scope of review. I've replied briefly in my final footnote in my reply brief as one of the arguments they raised that was outside the scope of review. And I've cited a portion of my reply brief in the Court of Appeals at pages 2 and 3. Reply brief basically does is take the word proceeding, quote, proceeding, close quote, and track it through the Rules of Civil Procedure, Chapter 52C, and the other general and other locations is pertinent. And it shows that everything we're dealing with, the matter in front of the trial court, the 60B matter, the affidavit matter, and the matter, they're all called proceedings. And our point is that if they're all called proceedings, then the same rules apply to them, except if the statute tells us differently. And the statute in 301 clearly tells us that this particular rule applies in a Uniform Act proceeding. This is a uniform we're having right now. It's not some new something. It's a Uniform Act proceeding. Thank you very much for your attention.
Oh, Chief, you're muted. Okay.
Thank you, Mr. Daly. Thank you, Ms. Daly, and thank you, Mr. Worf. Madam Clerk, would you recess us?
Oh yes, oh yes, oh yes. The Supreme Court of North Carolina will be in recess until the next calling of the calendar. God save the state and this honorable court.